Notice of a public meeting of the Ethics Advisory Commission. Pursuant to Chapter 551, Title 5 of the Texas Government Code, the Texas Open Meetings Act, notice is hereby given that a regular meeting of the Ethics Advisory Commission of the City of Brownsville will be conducted on August 19, 2022 at 1:30 p.m. at the Organizational Development and Human Resources Training Room located on the fourth floor of the Brownsville City Hall Old Federal Building located at 1001 East Elizabeth Street, Brownsville, Texas, and via WebEx teleconference meeting by logging in on the link provided on the agenda. Members of the public who submitted a public comment form will be permitted to offer public comments as provided by the agenda and as permitted by the presiding officer during the meeting. A recording of the meeting will be made and will be available to the public in accordance with the Open Meetings Act. Vice Chair, it is 1:35. We do have a quorum present. You may call the meeting to order. Next item on the agenda is moment of silence. There. Next item, we have public comments. We did receive one public comment, which is Ms. Ashley Alshire. Do I have standard?
No, you can go to the AMBO. We can
3 minutes.
Okay.
Good afternoon, Chair and board members. I appreciate the opportunity to stand here today. I wanted to ask a procedural question. I filed a new complaint this week, and I hastily did not include the subsections of Section 38, the violations that I feel should be accompanied in the complaint. But I wanted to ask if you guys still consider that complaint going forward without those subsections, or if I just need to submit that today to the Secretary's office or Monday morning, and you guys consider that. In my opinion, all of Section 38 has been violated, and so I just want to make sure that nothing holds up my complaint from going forward.
Well, we can't advise you what to include in your complaint, but I can tell you that as a body, we've decided that we're not looking for legal technicalities.
Okay.
And we read the complaint as a whole to determine whether or not what's alleged is a possible violation, and then we compare it to all of theirs.
Okay, that's great. My concern was just because of the, basic education level, that it's not a burden upon the public to know law in order to file a complaint. So thank you.
Sure, thanks. Any other ones?
No, sir. That's the only one we received. Next item, we have approval of minutes. Minutes to the meeting of June 24, July 22nd, September 9th, and October 14th of 2021.
Okay. Has anybody had a chance to go through the minutes sufficiently to any discussion on the contents of the minutes?
The matters you had asked for before have been included in them.
No. You're talking about the amendments to Chapter 38.
Well, you had wanted to give reasons for findings.
Oh.
And I just wanted to know, and it had originally been submitted bare bones, and you said, well, I want some reasons for findings.
Submitting a chairman's report attached to the order.
Are you satisfied with that?
I think so. I think that in the end, it brought to the city commission's attention the facts that we had adduced during the evidentiary hearing sufficiently.
Okay.
The only one that I did not go through in detail were the minutes relating to the evidentiary hearing we heard in this room. Okay, that was just wrong. I that didn't do that.
Mr. Stapleton, which evidence are you referring to?
The allegation that we had a board member who had made an ad hominem attack during Facebook.
Yes.
Oh, yeah. Okay, I'm sorry. That one, we didn't issue a finding because we dismissed it.
Okay. All right. And was that not the one that you wanted to have reasons?
The reasons were for the first complaint that we heard. That was improper benefit case.
I'll move that all the minutes be accepted.
Second? Tomorrow? I'm sorry. All those in favor say aye.
Aye.
All those opposed? I think it a vote of aye. I don't know if Mr. Merrill is able to, I guess he's listening.
Mr. Chairman, I'm listening and I'm trying to get to you. But
Okay.
I read those minutes and I'm okay with them. Although I do have a question about why they're so detailed, but I'm in route and I vote yes.
Okay, you had a question about the minutes?
I'm not experienced with this and I'm not sure why we have to have that much included in the minutes.
Oh, okay. Yeah. Sorry, so then I guess it'll be 6-0 is you voted to approve the minutes, and we'll come back and work on, I guess, the comments in the minutes at another day. Right. Good. Okay. So I can assign these?
Yes, sir.
Can we send them on?
The next item on the agenda is the work session, discussion and analysis preliminary panel procedures via hypothetical scenarios, continue from previous meeting held on July 21st, 2022.
Okay, and so I'm going to pass around and I'll put it on the screen here. At our previous meeting, we worked through a hypothetical situation. There you go. Actually, only one of these pages has actually got small on it. Oh, okay. All right. So let me see if I can, am I able to share my screen? In the meeting. Yes, yes, yes. Oh, yeah, okay. I got you. All right. I don't know if they can see that, but maybe people at home see it. So the very first page is the hypothetical we went through, and I'll just kind of walk you through it. It says, I'm the name of Susan Peters, complains against Paul Garza, saying I'm a teacher and I live in Brownsville. I to support the city of Brownsville functions by attending them, but I do not consider myself to be in local politics. Paul Garza is a commissioner of the city of Brownsville. A couple of months ago, I was at a restaurant and was sitting at a table very close to Paul Garza and Chrissy Tang. I know who Paul Garza is because of his position with the city. I have seen him at city functions several times. We are not friends. I know who Chrissy Tang is because I've seen her at city functions several times, but we are not friends. At the restaurant, I overheard a good portion of the conversation Paul Garza and Chrissy Tang were having. And I heard Paul Garza and Chrissy Tang discussing the fact that they had some sort of business. They refer to their business as unrealistic solutions. I heard them discussing that their client, Project Marble, paid them to promote a development project to various governmental entities in the city, in the Rio Grande Valley. I also heard them discuss the chances of getting the city of Brownsville to award Project Marble money for its project. I heard Paul Garza tell Chrissy Tang that she should hold on to the money Project Marble gave them because he couldn't take it. Last week, I saw that Paul Garza voted in support of the city of Brownsville awarding Project Marble an incentive package in the amount of $300,000. That doesn't seem right to me. I don't know if Paul Garza told the city about his business. I do not know anything about unrealistic solutions or Project Marble, and I didn't want to be involved in any investigation into possible ethics violations, but I do feel it's my obligation to say something. And so we went through this hypothetical to look at issues, what happens when you don't have a participating respondent, and you have someone, the complainant, not wanting to participate in the system either. And we walked through that process, what happens. On the second sheet is kind of the procedural posture for that complaint. And it says that complaint had already gone through the preliminary panel. It had found just cause and cited the 3 sections that could possibly be violated. Again, Paul Garza was sent written notice, and he was given 10 days to submit a written response. And through his attorney, Paul Garza submitted the following: I deny that I violated those sections. And then the evidentiary hearing on Ms. Powers' sworn complaint is set for June the 23rd. And Paul Garza has sent notice that he will appear through his counsel and not testify. Again, we're looking at what happens when you have 2 parties. One has made a sworn complaint, gone through the preliminary panel. You have a respondent who is going to appear through counsel but not say anything. And so then we're looking at how that works and how the subpoena process works and those kind of things. And that's how that is. Now, today we're going to be looking at the preliminary panel process itself, or what goes on in this. And the next 3 sheets are a form that I suggest that we use on a regular basis. And what it does, it kind of walks through, I think, the portions that are relevant into making an analysis. And gosh, is there any way I can make that bigger on the screen? Or do I got to go like this? Okay. So let me just kind of walk through some things real quick. Okay. There we go. Yeah. So one of the first things we get to look at, and these are the rules in Chapter 38, is jurisdiction. And jurisdiction of the EAC is limited to acts within 1 year. It's got a 1-year statute of limitations, however you want to consider that. And then it says that that's it. That's our jurisdictional limitation on that part. Another point in here, before we get into the workings of the preliminary panel, is that in Section 38-190, there is a confidentiality provision. And that provides that no city official or employee shall reveal information relating to the filing or processing of a complaint, except for as required for the performance of the official duties, right? And then all papers and communications related to a complaint must be treated as confidential to the extent allowed by law. And so there you can see, we'll talk about how that comes into play preliminary panel stage, but it's another little poll we need to be cognizant of, and that is really can't be talking about it. The third part, and this is something new for us, is the role of outside counsel. So we had talked about making amendments to Chapter 38, and those recommendations were taken to the City Commission. And the City Commission had come back with an outside counsel provision. And so each commissioner then selects one attorney to serve on a rotating basis to act, in essence, as a special prosecutor. And here, the obligation, so these are only in circumstances where a complaint is against a city commissioner or a director of a department or something along those lines. Nobody below that, where the city attorney would be conflicted out, is the only time. And so he has his duty owed to the Ethics Commission itself, and his duty is to investigate what the commission is telling him to look into. Also, he's got a 10-day deadline to kind of do an investigation and at the same time to produce some sort of report, something along. Okay. Now, the final thing I'd like to review before we get into the discussion is the preliminary panel process itself. And so the preliminary panel process is found here, and that's under the summary dismissal element. And it says that we're supposed to make these decisions of the preliminary panel within 21 days of receipt of the complaint. And the initial burden or the initial standard is just cause, and that is upon a reasonable inquiry that would induce a reasonably intelligent and prudent person to believe that a person has committed an act constituting an ethical violation. That's the standard for just cause. And then for it to be dismissed at the preliminary panel stage, it can only be dismissed by an affirmative vote of 2 out of the 3 panel members. Okay, those are the kind of the workings there. Complaint comes in, if it's against a city commissioner, on a rotating basis, I guess it's a lottery draw of some sort, an attorney gets assigned, it goes to the chair, the vice chair, who then calls the preliminary panel and then tells the outside counsel, we're going to do a preliminary panel, hold off on doing an investigation until we have a chance to look at the complaint. Okay, everybody have any questions about that? Okay. So what the next, like I said, this section here, let me see if I can share my screen. What? Let's see. Oh yeah, okay.
There you
If I shared, no, I'm not right. There's right there at the bottom next to record. Oh, there. Okay. So, oh, thank you, sir. Go ahead. Let's see. Just a brief recap. What we had gone over was the hypothetical we went over last time. We talked about his procedural posture. I just went over kind of like the 4 guideposts in chapter 38 because we're here to do a workshop on the preliminary panel. So the 4 kind of guideposts we talked about were jurisdiction, and that is there's a 1-year limitation. You cannot consider complaints that allege conduct outside of 1 year. It says a shall in there. Also, if it's against a city commissioner or a director, then an outside counsel is appointed, and that's through a lottery system by the city attorney's office. And then the preliminary panel has 21 days to make a decision, and inside that 21 days, the outside attorney is given 10 days to kind of do an investigation, who serves at the pleasure of the preliminary panel or the ethics commission at that stage. That's kind of where we're at right now.
Have those been appointed or?
From what I understand, yes. We've gone through preliminary panels now twice under the new system. I don't know if the full array has been appointed. Do we have all 7 or is it?
Well, we're missing only one.
Missing 1, okay.
Who are they?
Do you know the names?
From my head, not right now.
Okay.
But I do have a list.
How are you?
All right. And so what I've got on the screen here, and is what's in your packet, this is just kind of what we used recently to kind of go through a preliminary panel. And that was basically, if you're going to, whatever the findings are, it's got to be related. And you don't have the benefit of the attorney's office to put this together because they're conflicted. And so any decision has got to go to both the complainant and the respondent. And so that's why it leaves those blanks up there. It leaves a blank for the complaint number. And then it says, here are the following people who considered the panel, the chair, the vice chair, and then 2 members. And then there's a provision in here that provides that the preliminary panel did not hold the complainant the same stringent and rigorous standards as our pleadings filed by lawyers. Rather, the preliminary panel liberally construed the substance of the complaint, not the labels and citations contained therein. Kind of a liberal construction analysis of the facts itself. And then the part 3 says, well, what we gleaned or we determined from the allegations contained in the complaint are as follows. Allegation 1, allegation number 2. And then we look to see if there was jurisdiction. Again, that 1 year limitation is what the complainant saying happening within 1 year. And so then it looks to see, okay, by a vote of whatever, do we have jurisdiction? And if you have jurisdiction, well, if you no jurisdiction, then it gets kicked out. If it has jurisdiction, it's got two options, right? Either it gets kicked out or it doesn't. And so here, I give this one, I'm sorry.
No, it's okay. You're right above you.
That's okay. Mr. O, do you have? Yes, I did. Okay. And so if it does have jurisdiction, I'm sorry, if it doesn't have jurisdiction, it gets kicked out. So you go through A. If it does have jurisdiction, it can go two ways. It can get kicked out for not having just cause, or it can continue on. Okay. Now, if it gets kicked out for not having just cause, it's got to, you have to give the reason. That's inside chapter 38. So what we have in here is that if it has jurisdictions, and you want to dismiss it, one, it says the preliminary panel considered all of Article 2, Chapter 38. So that's all of the different possible sections that could be violated. The preliminary panel specifically considered the following codes, right? So it gives everybody notice about, all right, we generally considered them, and then we looked at these in particular. And then the allegations in the complaint are not required to be thoroughly detailed, with must be more than labels and conclusions and formulaic recitation of the elements of a claim will not do. So they just can't go in there and say, basically copy and paste the complaint or the chapter code, say that's it. They got to give some meat, some bones on there, just look at. And then if you're going to kick it out by a vote of whatever to whatever, it's got to be at least two. The preliminary panel finds that the allegations of the complaint do not state just cause, therefore it's dismissed. Or if you find just cause, then you use the last one. You don't have to have a vote, and it just goes forward. Does everybody understand it so far? That's just on the form. That's a suggested form. Okay. Okay. So that's an overall process of the preliminary panel, and I have a hypothetical to go with. But before we do that, does anybody have any discussion or points that you want to talk about that preliminary panel process?
I'm curious about the definition of just cause. I mean, do we have, is that,
It's in the code itself.
okay, that's what I wanted.
Yeah, let me share. So it is. This is found on.
It's actually at the bottom of
38-190, and then it's E1, and then
Got you. Thank you.
that's
Have that. Please. Perfect.
okay. Anybody else have any questions or comments before we move on to the workshop? What we'll do then, the last page on here is the hypothetical. And let me see if I can put here. Okay, so I'm sure the right one. Edit mode. Done this one. Let me put the other one out, sorry. Sorry.
Is there any way I could ask a quick question?
Maybe at the end.
Okay.
Let's see. Okay, let's see this one.
Okay, you know?
Hey, before I change,
Oh,
Well, let me. So again, we got the same two people again. We have Susan Peters playing a Paul Garza, and so the nature of the allegation follows. Paul Garza is the commissioner of the city of Brownsville. Paul Garza and Chrissy Tang have a business called Unrealistic Solutions. Unrealistic Solution has been promoting a development project called Project Marble. The city of Brownsville awarded Project Marble an incentive package in the amount of $300,000. It doesn't seem right to me. I don't want to be involved, but I do think it's my obligation to say so. And again, this is sworn. Okay. So, a lot less detail than the previous hypothetical. And so what I would like to see what we can do is just kind of walk back through maybe the form that we had talked about and how we come to an understanding of what we're trying to do. So my suggested form is the first thing we take a look at is read the substance of the complaint. What do you see it being complained about? Does anybody have a comment? What do they read that to be complaining about without citation or anything, just the facts?
Financial conflict.
Okay. And so do you, everybody agree with that? Is some sort of financial conflict, is an improper issuing of money, so on. And so if that's the case, let me go back over here. We look at then jurisdiction, right? Does this financial conflict issue, is it within the jurisdiction of the EAC just on its face? And so, do we see anything in here that, you know, as a preliminary panel, you would feel comfortable voting on finding jurisdiction? Say, all right, I see something here that can be pled to trigger jurisdiction in the complaint.
Assuming it's timely, I'd say. We're assuming it's already been through the 1-year vetting process.
No, it hasn't. So this is a naked complaint coming to us. And the city attorney's conflicted out because it's against the city commissioner. So it's just, it had gone to the chair, the vice chair, the substituted panel member, and then the outside counsel. And that's all that the complaint says.
Well, I guess the issue would be that we don't have facts to determine the jurisdiction issue, right? We don't know when this occurred. Correct. Now then the issue becomes, as a preliminary panel, you know, are we allowed, or to what extent are we allowed to go outside of what's before us to kind of make our determinations? So that's the issue that I would see.
Right. And so
we go look into minutes and see when these issues came up to see that we do have jurisdiction or not.
Well, that would be a point because, like, so that $300,000 award should be easy to find, right?
But are we stuck to, on its face, we are committed to making that decision based off of what we've been given? I don't know that we should go outside the scope that are, if we're determining jurisdiction, I don't think it would be proper for us to go outside the set of facts that's been provided to us.
My concern in the last meeting, asking a question, how much credit can we give to such a conversation somebody heard? And how, you know, truthful it is. And just say something against the commissioner. And then I read it here that the commissioner denies that. So who's right? The person that is saying that heard something, you have an issue, or just the commissioner said, no, I denied that. So just to dismiss the accusation.
Esther, just to be clear from me, this is at a point where 3 people have received this complaint. They're sitting down and deciding how far to go.
Correct.
And what I'm hearing is we don't ask for a lot of details. We don't even necessarily assume that it's filed timely.
Well, right. So it comes to us, and then we're not holding anybody to pleading standards, right? Like as a lawyer.
And in fact, the commissioner may not even know about it yet.
No, I think they are notified.
Yeah, they are notified.
Notified when it's filed?
They're notified when it's filed.
When it's filed, not after it's been to the preliminary group.
No, that's right. So it comes to the city secretary's office, They see that it's against the commissioner, they go under the commissioner and then one to us, whoever the us is. Thanks. And so then we've got to make that initial discussion, right? It's like, okay, do we see on here a jurisdictional deal? And now, for instance, this is why I want to workshop this. Let's say that there's a significant grant that we all know about. And it happened 2 weeks ago.
Yeah.
Right? And that number was in the newspaper forever. We all know it happened in the last year. You know, are we going to hold the citizen to a drafting requirement that requires them to specify a year? Or can we take facts that we know they're in the public and find that there? Because if not, we need to. How do we give the public notice that you need to be specified on the dates?
Well, I think at the very least, I mean, on its face, it wouldn't be sufficient because you don't have enough, right? At the very least, I think a time is appropriate. And I don't know, I don't recall what the form for submitting a complaint says, but I would argue that needs to be then included so that we are at the very least have it, because on its face, I don't think it's appropriate. I would argue that we don't have jurisdiction because we don't have enough facts.
True.
He says a couple of months ago, and then we have a June 1 date on when the claim was
Okay, he's looking. Yeah, that was the last hypothetical. That was a prior. Yeah. So this is
Garza.
yeah.
Paul Garza, she says, a couple of months ago, I was at a restaurant.
Right. That was so the reason why that was the last hypothetical, and that one's easy enough, right? Because that one gives some time.
Some exactly.
Right. And then, so this one is completely lacking in a date or a reference point.
Oh, all we've got is this complaint.
That's all we're analyzing there. So that's all it says. That something happened, sounds serious, but there's no reference to a point in time.
Mm-hmm.
Yeah, I think we've got to have some way to inquire.
Mm-hmm.
Well,
But no question. Do we as a preliminary panel inquire?
Should we be investigating at that point?
Or is it on its face? This is what we have to decide on.
Yeah, I don't like the idea of tossing out a complaint just because a layperson wrote it and didn't put all the right stuff. I thought it's, hey, when this happened, just somehow, whether we bring them in or we ask them to send them a question or something.
Mm-hmm.
So what stage, I'm sorry to interrupt, it's a good discussion, but what stage are you in right now? Preliminary?
panel. They had just come in, and the preliminary panel is just initially meeting.
I think you, if you look at 38-190, and it's E2. E2, there you go. I think it says, so we're at the preliminary findings. I think it says, based upon the statements and evidence submitted. So I think you have to base on his face.
Just on it. So, yeah, and I was on a preliminary panel recently, also won't discuss anything that was in it, but yeah, this is kind of a difficulty, I think, trying to figure out, do we take it on its face? It sounds like that's what we need to do, but I think that it needs to be, first and foremost, I don't think I agree with Mr. Stapleton that we should not hold the public to some really strict standard of pleading, right? Citations to specific sections, the code that they kind of violate and things like that. I think we should kind of work through it. But I think that, obviously to get past that phase, there needs to be specific facts. So there's got to be some understanding that if somebody is submitting a complaint, we need specific facts, dates, times, potentially. How that gets addressed, is that addressed in instructions on the form or instructions on the website or something to that effect? But it needs to be addressed somehow. Otherwise, I think this is going to be a common occurrence, right? We're going to have something that's so broad or vague that maybe there's something there, but without more specific facts, we can't really make a determination, I would say.
I mean, is there an opportunity that we can give to cure?
So that was that was one thought, and I don't want to make it too much of a legal type proceeding. But one thing that might was that we could potentially issue like a preliminary decision stating there are not sufficient facts. You have so many days to supplement. I know that almost sounds like with like an board with supplemental or whatever. But, that may be another way to address it and say you have so many days to provide additional detail. Otherwise, we're going to find, we don't have jurisdiction or that there's not sufficient facts.
Well, of course, I mean, just on the day, statute of limitations burden tends to be on the other side. So they would have to come forward and say, hey, this was more than a year ago.
Well, the only problem is the language of 38-189, and it says the commission shall not consider complaints based on.
Yeah.
And so we have a hard, we can't even get to the point of an analysis of the merits.
Yeah. Well, and I think we kind of came to the consensus that as written, this document doesn't really function.
38? It needs some tweaking, that's for sure. Right?
Well, it creates a situation where you can't really make a complaint. Or if you do, there's no standards to do anything. I mean, I think one that we heard, everybody kind of wanted to do something, but we just didn't have any teeth in the 38 in order to get there. And so, I mean, this is probably a crime described here. It would seem like if it is in fact a crime, that if the ethics committee does anything, they also ought to be able to point out an ethics violation. And I agree with you that the language of that does not permit it, but certainly we can't do anything with this. We might as well say, hey, don't bother.
But so that's one of the things we want to just at least air, right? Because preliminary panel service is going to be coming up to everybody pretty soon. I mean, over time. And this is just at least one issue in our experience of the preliminary panel we've come up with. It's like we read the jurisdictional rules, what are we going to do? And how much, again,
Fact finding can you do in the preliminary process is part of the issue.
well, so that gets back to the outside counsel. And so this is what was the newly created body. And so because it's against the city commissioner, an outside attorney is given over to the commission. He's a member of the preliminary panel. And this is just my thoughts on the reading. You do an initial analysis of, is there jurisdiction? Okay, if there is. And then you go to the second step and say, do you find just cause? And to look at just cause, do we have facts? So we got 21 days to make the decision. The outside attorney's got 10 days at same start date to complete some sort of report. So if the preliminary panel meets as soon as possible, you don't have to make a decision, but then say, hey, look, let's say whatever, the panel decided, yeah, you know what, we all know that $300,000 was voted on 2 weeks ago. We know this happened. We all as a body are finding jurisdiction, right? But outside attorney, would you please go get the minutes for this vote? Would you go please get this city commissioner's disclosure forms on this vote? And would you please get this city commissioner's monetary disclosure, whatever they have to have an interest in or something along those lines. And so you have enough time in that 21 days, 3 weeks to have that attorney go and do some of that kind of stuff. Okay? Does that make sense?
And it's still in the preliminary phase.
Yeah. You don't have to make a decision. You can just,
You can do a little fact finding.
yeah.
You can say, we don't know yet enough. We'd like to have some more facts.
Yeah. And you don't have to even, at least here, you don't have to give anybody notice of it. You can meet initially, kick it around. You know what? Outside attorney, would you go please get these documents?
Figure this out. Get us something to understand better.
Now, the flip part of that, okay, so here we're talking about a financial situation. But let's say the situation involves something heinous. And this heinous act will serve to tarnish the name of the city commissioner. Just association, right? And so that the only way to do that preliminary analysis is to go and talk to the relevant people, right? So at what stage are you going to go send an attorney out on behalf of the Ethics Commission, go and talk to people and ask, hey, does the City Commission do X, Y, and Z? Because, I mean, I would think every commissioner is entitled to some sort of presumption of compliance with 38, unless there's specific facts. But it worries me that at the preliminary panel stage, you're sending out an attorney to go and do fact finding. That it could be completely baseless and meritless, and then only serving to injure the reputation of the commissioner for no reason at all. And so,
Wouldn't he be under some sort of secrecy?
right, but let's say you're interviewing witnesses. You've already just told that witness, Commissioner so-and-so is involved in this heinous act, or is alleged to have been involved with this heinous act. I mean, that's more than anything is the real big concern that we have is where do you strike that balance? You know, going and asking for the city records on stuff, it's piece of cake. Going and do real estate records or corporate records, piece of cake. But when you get into things about witness interviews and talking to people, well, I think that's when things get kind of, at least on my side, worrisome. And I wanted to put that out there and maybe come thinking about that.
How do you feel about the just being able to talk to the commissioner and get a response so you get both sides of the story?
That's available.
You know, I think at a minimum that, and then if there's some disputed facts based on something that happened, you know, this happened at the restaurant, wherever it was, then if there are eyewitnesses, he should be able to talk to them. Just kind of get an idea. And that way there would be something to make a decision on. But, you know, short of that, if all we've got is an affidavit by one side, and the commissioner has not had a chance to respond, if there's a fact dispute, we're going to have to decide who resolves that. But I'd kind of like to think you could get an investigation and see what it is. You know, if there's pictures. Everything's on somebody's phone now.
I was just going to say, it's just thinking out loud a little bit about it. I was going to say that I can see how you would ask for record keeping research. But the point at which you would be collecting information that involved going to see a witness would have to be pre-approved by this panel, the full panel, rather than by the preliminary group. In other words, the preliminary hearing group would have to be able to say, there's enough here so that we take it to the whole committee. But our recommendation to the commission will be, here are the facts as best we have them, and then dispatch anyone who's going to do the investigation. But I wouldn't want anybody out there doing police work, so to speak, prior to the time that the full commission had had a chance to consider. Now, that's just my thoughts.
Anybody else have any thoughts on this stage? Because this is a very tricky part.
Mm-hmm.
it's, you know, you're subjecting people who stood for election, sacrificed their time, and, you know, are they being, you know, tarnished just because someone filed a bold complaint? And are we sending somebody out to go question people on that? And that's just it's a worrisome thing for me. And that's just my own personal opinion. The records are easy, but so the other things are where it gets to be difficult.
I would argue if we are, as a preliminary, whoever's on the preliminary panel is subject to it's making that determination of jurisdiction on its face. I don't think that we should be investigating anything at that phase. I think just cause is, not, it's not so high of a burden that if it's there, it's there. I think that anything that's going to be investigatory needs to be subject to the entire panel's decision. And I don't know that I would like to give the community an opportunity to be able to cure their mistake, but I think that they can, it's not like it's double jeopardy where they can't resubmit a complaint.
I don't know that.
Can they?
Is it?
It doesn't say. I don't think.
I don't remember. I looked before and I couldn't find it.
So, for example, if the preliminary panel says, you know what, on its face, we don't have enough, please resubmit, or we have decided against it for X, Y, Z, then that still gives that community member the opportunity to resubmit correctly, right? And then if the prelim panel finds that there is just cause, then that's where I think as a group, as a whole, we should be able to make decisions on investigatory
Okay, so
cases.
with that, if you look at the current hypothetical, right? So it says that Paul Garza is the commissioner, and him and Christie have a business called Unrealistic Solutions, and Unrealistic Solution represents Project Marble. Project Marble got money. So there's not a whole lot of facts there.
I think it states a complaint.
Okay.
And so then at that point, when you decide if somebody needs to call Christie and find out, at least what she says, there's an eyewitness, if there's anybody out there. I'd hate for somebody to suck it up and come forward with something like this. Then we say, well, no, you just not, you haven't set them up now. If you're, and we reject it. We just,
Right.
There are a lot of administrative agencies that are just black holes. There's no real point in. If you try to file a commercial, there's supposed to be an ability to make them against banks, against insurance companies, against again on consumer complaints with the Attorney General, and they just disappear and never heard of again. We can do that and say, well, we've got a black box here, you throw your stuff in there, but all we're doing is
we're misleading the public.
yeah, it's misleading. If you're gonna have an agency, otherwise they should know not to come over here. If they've got a complaint, take it to the district attorney, whatever they're gonna do with it, but don't bring it here because we're going to be hyper technical. We're not going to let you pass to phase one, and we're not going to tell you why.
And again, this is just bumps in the road and come through all these things. And so I don't know if there's even a black letter right or wrong, right? It's the membership of that panel at that time, whatever they determine. I do, the part here where the attorney who's been assigned, the outside guy, he's got 10 days to produce a report, right? So that's 11 days before our decision time. And so if a complaint comes in, that's day one. The outside attorney's got 10 days to produce a report. We have 21 days as a panel to find just cause. Now, that 10-day could be extended according to, I'm sorry. Oh, why? Can you make that smaller just a little bit? me just scroll down here. Okay. Oops.
So let me catch up. So it's filed with the city attorney on a regular business day.
City secretary.
City secretary, I apologize, with the city secretary, assuming that it is an allegation against either city manager or the commissioner, and it's assigned rotation basis or arbitrarily to an outside counsel.
Yes.
The outside counsel, from the time that they learn of it to the time that they have to report back, is 10 business days.
That's what
10 days.
Yeah.
And at that time, the preliminary panel, the three people, get back together and say, do we have just cause? Shall we proceed? Yay, nay, maybe. Okay. Now, trying to make sure I'm in track.
What I think is a practice that should be considered is that, so we get notice, if you're on the panel, you get notice the day that the complaint is filed. And so if you're the chair, vice chair, try to get that preliminary panel notice set as soon as possible to do this initial analysis and then discuss with the outside attorney is in any documents that we need, like in corporate records or minute meetings or whatever. And then you can resume and say, okay, after we've done this, okay, these bare bone allegations seem to flush out, relatively easy to figure out just cause. Or we don't do it, or you just kind of look at it and just say, like we were saying here, it's three people, and what is the majority saying on that thing? I see something here. I don't know. These are the things that it's tough to deal with, and to share that.
However, during that 10-day period, the outside counsel is working for the preliminary panel, not for the ethics commission at large.
It says the commission, and I would imagine that he works for the panel, but I don't know. Maybe I'm wrong.
Well, seems to me that if a complaint is filed, there may be something that is on the face of it. Yes, we need to proceed. Preliminary panel would at that time say, yes, this is definitively something we need to proceed with. They hand it over to the outside counsel at that point. Outside counsel does the research before the full ethics commission is convened or after the ethics commission.
Well, he's supposed to do his report before the just cause finding.
Okay.
So then the preliminary panel would meet, but would not make a decision until the investigation is done by
Right.
the attorney.
Yeah. Now, these deadlines can be extended as need, but yeah, that's seen in the code. So it does take a root. It's like as soon as you get it, you got to set it and then have that initial discussion. And if we're going to require documents, then go get them, please, and then we'll make a decision. But then it gets to the part, if we're going to talk about witnesses, that's where it gets to be sticky.
My own feeling is that you wouldn't do anything that could be circulated in the public other than just investigative records. My own opinion. Wouldn't do anything.
Your question is whether you call witnesses during the prelim phase?
So let's say that the alleged misconduct involves, Chrissy Tang. Do you go send out the private attorney? Would you go call up Chrissy Tang, figure out what she's doing?
No, I'm vehemently opposed to that. No. Something
That's why we're fleshing this out. I mean, so you have a complaint without a whole lot of facts. This happened at this day and this location, that kind of stuff. And the easiest solution, like Mr. Saban was saying, was go talk to Chrissy Tang. Right? But at what point do you do that?
I think at the preliminary stage, talking to somebody, we're going to talk to them about facts. They could deny them. They're not subject to any sort of a cross-examination. I don't know. The way I see the preliminary panel is, and it says here, we've got to base it on the statements and evidence. So I think going outside of that, we're already running into issues. I think that the preliminary panel needs to look at the complaint. I think they should construe it as liberally as possible without focusing on did they cite to the specific rule, right? I mean, we can look at this hypothetical and we know there's an ethical violation that's going to fall under it just by reading it. We don't have to, oh, they didn't cite to whatever section, right? But you know, there needs to be more specific facts. I mean, if there's something that's and there's a little bit more specificity here, but if somebody says, you know, so and so accepts bribes, right? You know, we know that is, you know, that's going to be an ethical violation if it's true, right? But what is the basis? But yeah, exactly. So what's the basis for that allegation? What are the facts that support that? How do you know that? What instances can you tell? I mean, that's what we need. We need, if there's a complaint coming to me, then I'm going to say there's just cause. I need to say that on such and such date, so-and-so, you know, accepted bribe, or I, you know, it's been communicated to, something that gives us something to go on, to where we can actually say, okay, there's something that we can now really investigate. There's enough information here. There's an ethical violation that now we can investigate and or go on to the panel to discuss. But so if you get something that's more bare bones, I think that the appropriate thing to do, again, so that it's not, you know, again, we don't want to make this process overly complicated for people to where they're going to submit something and it's just deny because you're not specific enough. I don't want to turn this into that. I think there needs to be either clear instructions that you need specific facts and allegations to consider, or an opportunity to report, right?
And I don't mean to interrupt, but I think the website, and maybe not so much the application, but the website does specify the ethical violation and the facts which are alleged to support that. And so I don't know how much clearer you can get.
Mm-hmm.
Well, maybe a date though. I mean, because if we're going to be kicking things out.
Well, okay, so maybe the answer is as long as be more not so liberal. Hey, the facts have to be there to support a just cause, but maybe being a little bit more liberal when it comes to citing, and maybe an unsophisticated person that's citing towards, the wrong citation, we're not going to be so strict. Is that what you mean?
Yeah, I think that we shouldn't be strict like that. I mean, I think we should look at the face of the complaint, and there are facts that are being alleged that fall under a certain category. We should analyze that. But the problem is having, specific enough facts to be able to say, yes, we should investigate. Because again, just saying somebody accepts bribes, you hear that and you say, okay, well, yeah, that's an ethical violation. But like, what does the preliminary panel then go to the board to go focus on that? Now, are we going to go look at the records of that person that allegedly accepted bribe and say, give us 5 years of your bank records? Do you see what I mean? We have to have something that we can actually say, let's focus on, okay, they received a bribe from a certain entity or person. Now we can hone in on investigating those facts, right? If it's too broad, at some point it just becomes, what can the preliminary panel do? Other a fishing expedition to examine everything that person that's being investigated has done over the last few years or whatever.
My instincts would be that the 3-member panel would be able to say, for instance, on this, they look at that and they say, you know what? If there's anything there, we need to look into it. Let's get at least the records and then get back together and see if the records support the dates, the sequence, the outcome. Then the panel could say, well, all the efforts, everything looks lined up, maybe we should, so at that point you'd say, let's serve notice and go forward. If somebody came in and said, I don't like specific Commissioner Paul Garza because I know he takes bribes, well, thank you very much for reporting, and don't let the door hit you, so to speak. Don't go away mad, just go away. That's what that 3-person panel is there to do. I don't know the law on this, and y'all do. There's also the potential if it's too far into the details or get too bogged down in the legal details, we open up the opportunity for somebody to claim, if they ever did end up in criminal court, to be able to say, these guys screwed the whole thing up.
Oh, they'd have to, well, and please don't assume I know any law. But they would, if on this complaint, if I represent Paul Garcia, he's gonna not respond. And we can't let him because if he's guilty, he's gonna have to say some stuff that hurt him. But, you know, the other hand, in almost every complaint, there is some investigator who's asking questions. So you call and say, Christy, did this happen? Say, no, it couldn't have happened. Paul and I were in Cozumel during that month, or, you know, or it couldn't happen. I can show you the ownership of unrealistic solutions, and he doesn't have anything to do with it, or, you know, I mean, any number of responses could be made, but you just don't know until, you know, somebody's talked to them. And then if they want more details, they go back to Susanna and find out what those would be. I mean, because I don't see how you can get enough to formulate a complaint, make any evaluation without talking to people, and they may not want to do it by affidavit, or, I mean, to me, ideally, the lawyer appointed just gets on the phone and makes some calls and makes some notes, and then you would have sort of a preliminary report, and you could have something to look at. And if it's a misunderstanding because it's impossible, well, then you know that too. So I'd like to see this lawyer, or you may want to appoint a cop. I don't know how you want to do that, but you know, somebody who can ask some questions and decide whether or not there is a probable cause affidavit that would support the complaint here. Because short of that, you're just in the dark. And I think you're almost always going to have to deny any complaint if there's a conflicting facts. And then if you've got Paul and Christy not, they could make their response if they wanted to, but it'd be good to kind of find out. And I acknowledge that under 38, none of it can be done. I'm assuming that what we're still talking about, because I would suggest under 38, really nothing can be done. And so I'm just suggesting that if you're going to rewrite 38 so it has some meaning, then there's a possibility to go with.
On the next workshop, about rewriting, we'll talk about it. But right now, because we do look, the reality is we're having complaints coming in. Yep. And so we're going to be staffing or constituting panels. And this is just, the purpose of this is just kind of like, okay, these are the instruments that we have to work with. That's chapter 38. And when we're trying to balance all the interests there, public's interest in filing the complaint and having it read thoroughly, the interest of the elected official, the dignity of the office, and then the city in general, just to make sure the process is fair. We're given some tools that we may find to be imperfect, but we're going to have to use those tools.
Well, they're more than imperfect, aren't they? I mean, you can't, there's no complaint except a financial conflict of interest. And if that's all that's dealing with, because we've already decided everything else is too general for enforcement, right?
Well, no, we still, the ones that we kicked out were the ones that said a commissioner should, or a city official should. There are provisions in there that do prohibit an elected city official from lending out his prestige of office. So that's one that's considered specifically, and it's 38, 25, or 20, 38, 20, sorry, 38, 23. I can pull it up here in a second. Let me see. But so there are those things. You can't go in there and have a city official, according to the chapter 38, go in and influence employment decisions. And
Indiscreet,
yeah,
ethically.
yeah. Let me see if I can just.
Can I repeat myself? I apologize in advance for repeating myself, but what I hear us getting to is the sequence as much as the process of how things unfold. In other words, there's the filing, there's the preliminary committee meets. Do they then, and they say, you know, it sounds like we need to do something here. You can ask the attorney at that time to do some preliminary investigative work, be it whether, and putting aside for the moment, whether it's talking to people or just pulling out records. And that person then comes back to the preliminary committee and says, this is what we've got. Here's the best information that we can get. The preliminary panel would then at that point say, they may say, actually, we don't even have jurisdiction because this thing is 3 years old. Or they may say, we don't have jurisdiction for some other than that, there's really not.
Yeah, jurisdiction just a year.
But I think under the current rules, I think you can only look at on its face. Couldn't ask the outside counsel.
Do an investigation. And I think what I was.
That's what I'm trying to get to. I apologize. That's exactly what I'm trying to get to. Is that out of sequence to have them do any preliminary work based on what the panel says?
I think any investigation would occur when it comes to the full body.
Okay.
At that point, that's when they start doing, because the standard is clear and convincing evidence, right? So based on its face, the complaint, if you have enough facts to support the alleged violation, then based on the clear and convincing evidence, you kick it up to the whole body, and then you start the hearing process and do the investigation.
And see, that's why I think the implications that the consequence, if this board does find an ethics violation, are pretty serious. And so I think that my opinion is that clear and convincing is not such a high burden that someone, I mean, as long as their allegations are fact specific enough, we should be able to find clear and convincing. Theoretically, it's such a low burden that it should go to the rest of the panel. So that's why my position is that it stays that way, and then any investigation be done as a whole, as a group.
Yeah, the way I see it is the preliminary panel is like a gatekeeper.
Mm-hmm.
It's a gatekeeper, right? And so before getting into the weeds and investigating and doing all these things, we're making a determination if there's something sufficiently stated that look at, right, that we can actually examine. And weeding out something that would otherwise be frivolous or too general with not enough specific information, because, you know, something like somebody alleging, oh, so-and-so accepts bribes, and we just say, okay, well, that's enough. That's an ethical violation. Let's take it to the panel. Now we're dragging a commissioner through without anything specific, right? So there's got to be that balance. And I think if you're doing the investigation at the preliminary panel stage, and the attorney's coming back with, hey, this is what the findings were. Well, what's the point of the main meeting, right? As a whole, for us to decide, I think we all need to look at the evidence and make those decisions. Mm-hmm. So to me, the preliminary panel is just the gatekeeper to weed out but at the same time, I agree with the whole mindset of not making it too burdensome on people pleading. And so I think we should be liberally construe the pleadings, but we need, you know, sufficient factual allegations. That's what goes, if they don't provide that, if they don't provide enough for us to otherwise be going on a fishing expedition, then we need to at least say, you know, we cannot make a determination without more specific factual allegations. We plead within so many months. Otherwise, we're going to dismiss the complaint. If they refile, then now we look at something specific. Is there something there? Is there jurisdiction? All those things.
I think because it's such a low burden, clear and convincing and just cause, that if you're not passing that threshold, it's because you're not including, it's a very general, he's accepting bribes, right? So I think that just the fact that the burden is so low, if you can't pass that, then you can't pass,
I mean, like looking at this example too, Paul Garza, commissioner of the city of Brownsville, and he, on realistic solutions, he might be on their board or something, but just by that alone, if that's alleged, that alone is not a violation, right? I mean, everything is going to be on a factual case-by-case basis. Just because an individual, and it's even more because under the ethics, what might be unethical at the state level is going to be unethical at the city level. But we go a little further in some instances, right? Because in other cities where they don't have net decisions, they can do business with the city, and that is not illegal. They just have to file an affidavit with the city secretary and abstain from voting on their own contract, right? So I think when you look at clear and convincing evidence, do you have enough facts? Being a member of the commission, being a member of a body without anything else doesn't really equate. So I think that's what you're looking at. I think, like what you said, you're looking to see is there enough evidence, enough information to support that there was a violation of Chapter 38. Right. And so, and it doesn't even say you have to allege a particular section, like the gift provisions. So,
Besides that, when I read here, the allegation says, I do not know Mr. Dawson. I do not know Christie. I know who they are, what they do. And then after that says, I don't want to get involved. So I just throw the bomb and...
Well, that's, do we want to have a reporting, like someone who's really legitimately scared? And like, look, I mean, I'm gonna have a small-time job. I need my job. I think this is wrong. It needs to be investigated, but I don't want to be the one to do it. That needs to be told us too. And so what I have on the screen here is 3832. It's titled Unfair Advancement of Private Interest. And it says, as a general rule, a city official may not use his official position to unfairly advance personal interest by granting or securing or attempting to grant or secure for any person, including himself, in form of special consideration, treatment, exemption, or advantage beyond that which is lawfully available to every other person. I mean, that's a fairly broad ethical limitation. And so that's where we get into these ideas like, all right, so that can come up a lot.
Oh, yeah.
And so what I'm just trying to, when we talk about being on the preliminary panel, just know that these issues are coming your way.
Yeah, there's no way that you could ever make a decision on that, could you?
I don't, yeah.
Who gets to say what's an unfair advance? I mean, it just gives you no teeth whatsoever as far as, I think anything filed under that section, we'd look at it and say, well, they can't show that it's an unfair advance of those interests, and we're tossing it. Anything filed under that, I think, would probably be tossed.
On the other hand, I can see how, and I've been aware of and lived through circumstances where I've seen it happen. And it's the old thing about pornography. I don't know how to define it, but I sure know it when I see it. There's a point at which common sense prevails, don't you think?
Well, if you, common sense and the law you're talking about.